difference there.
So if someone thinks that they have a problem with a product and they were to come to see you, go through briefly, if you can, the process. I assume that you'd have to tell them that the difference is here in Rhode Island, this is
Right.
what happens, or what happens in Mass. But what's the process, David?
It's very similar to the process we described with an auto accident or a medical malpractice case. You start out with the interview. And at the interview, what the attorney's trying to do is determine what the facts of the case are and what he has to explore. For example, when the young lady who was injured by the bottle that broke came in, we knew immediately, in order to establish there was a defect in the bottle, we had to get to the defect. So if the defect is with an automobile, for instance, we have to make sure the automobile is saved, and we need to get an expert out as soon as we can to take a look at it. Just like malpractice cases, product liability cases can be very expensive to pursue. So usually attorneys looking for a lot of damages before they're willing to put the time and money into the case that's going to be required. So you get the facts at that first interview, determine what you have to find out. Then you have to find the right expert and get the expert out to take a look at the scene of the accident, if that's what's involved, like in the auto accident with the accident reconstructionist, or an expert in the case that we had with the glass company. Believe it or not, our expert was an expert in metallurgy. Metal being, glass being considered the most fragile molten type of metal. And on cross-examination, it was interesting, he was voir dired, which is when the other side gets to ask him his expertise to determine whether or not his testimony should be allowed. Mm-hmm. And one of the books he wrote about, or articles he wrote about, was broken artifacts in archaeological digs. And the lawyer asked him, well, how is that relevant to this case? And he said to him, well, it's very relevant. When I find a broken piece of glass in an archaeological dig, I can look at it and determine whether it broke by accident or if it was a result of a manufacturing defect. So it's very relevant. So you have to make sure you determine what kind of expert you need, secure the expert, and get the expert into the case as reasonably quickly as possible.
Now, you said it can be expensive. Is that because you have to take the time to find that appropriate expert witness and do that interviewing and vet that? And does it take a long time to go from, I have a problem, David, to here's my settlement?
Well, yes, it can. And the answer is yes and yes. The process takes time, and the expert costs a lot of money. Just like in the medical malpractice case, where you need to find an expert doctor who's willing to testify or at least look at a case for you, and they're going to charge you a large amount of money. The experts in different types of products liability cases are also going to charge you a fairly substantial amount of money, and if they're going to come in and testify, it's going to go more. And I've seen cases where those experts could be as much as $100,000 or more. So
really?
You don't want to have a case that's worth $50,000 or $60,000 where you're spending $100,000 to determine if you have a case or not.
In which case, what would you say to the consumer who comes in with, I have a broken thus and such, who's taking care of that cost or whatever?
Unfortunately, we would have to say that the damages don't warrant pursuing a case. If they wanted to put up the money to do it, you know, we'd help them through with it, but we'd refer them to someone else to see if there's an attorney willing to do that.
So this isn't something that you typically take on contingency?
The fee is contingent.
The fee is contingent.
The costs, usually the attorney will take out at the end if there's a substantial enough case to do that. But if there's not a strong likelihood of recovery, or more importantly, the damages aren't going to warrant a big enough recovery, most attorneys wouldn't risk their own money to try to determine whether or not a case can be brought to a conclusion when, even if you're successful, it's not going to be enough to cover those costs.
On perhaps a related note, those who've had experience with fen-phen, the drug that was helpful supposedly in making someone lose weight or enabling someone to lose weight, deaths resulting. So someone who is a survivor is likely to come to you and say, there's a problem with this product. That ended up becoming, I think, was it a class action suit?
Right.
How do you know when you have a problem with this particular bottle, this particular cap, these contents, or it's something that's larger in scope?
All right. Our practice generally works more in terms of individual injuries from an individual product that was defective. When you get to class action suits of that nature, what you're looking at are law firms that specialize in these mass tort cases or class action suits and it does involve drug products a lot of times. Fen-phen was a well-known one. I believe Celebrex perhaps might have had some issues. I'm not 100% sure about that, but there are many different kinds of drugs that have caused injuries that attorneys who specialize in those class action suits have brought. A lot of times people will come to us and say, do I belong in that class or not? And their injuries could be severe, and perhaps if they're severe enough, they might find an attorney who would take the case on individually. But for the most part, those injuries are such that you belong in the class, and you don't usually want to opt out of the class if you can avoid it and just become part of, see, like I said, they're very expensive. And these attorneys who are doing these class action suits have poured millions, not hundreds of thousands, millions of dollars into developing the case. So you want to be part of that usually.
And they've taken plenty of time to do that, obviously.
Exactly.
Would you be the one who is likely to say, I think there have been similar complaints about damage, defect, or whatever you want to call it. Let me check to see if that's something that's currently being considered as a class action?
We do get that quite often. People come in and they give us the product that they were injured by and say, I was wondering if you could help me with this. And oftentimes we will do the research and get back to them and refer them to the appropriate attorneys or groups that are handling those types of cases.
At what point do we have to think about it's just about me and buyer beware? Do I have to, is the onus on me to read every label, every disclaimer, every warning? As you say, if you buy something at one of the big box stores and you have a technical manual for a small product, it's voluminous. I'm honest, I'm not reading that entire thing. Does that mean that the onus is on me if I didn't read that and something goes wrong?
A defense to a product's liability case is misuse. An easy example is if you have a table saw in your garage and you use it as a step stool to get something off a shelf and it flips over and you cut yourself on the saw, that's a misuse of that product.
Yes.
Even if there wasn't a guard on the saw that should have been there, they're probably going to get a defense verdict because you misused it. They will argue that you are responsible for any information that's given to you with the product. And if you didn't follow the rules or you didn't read it, and by reading it, it would have made a difference, then perhaps that can be a defense. Sometimes, though, what's in there is such small print and you need a magnifying glass to read it, you can argue that that is not something that you can be held liable for because no reasonable person would have ever taken the time to get the magnifying glass out to read that.
It certainly does make us think that we need to go back and look at those manuals a little bit more, though. I mean, some of the description that you just gave, for example, I know I shouldn't be standing on top of that table saw. That would be a little more obvious, but when it comes to some of the tools or pieces of equipment you might have for even your home fitness center, if you didn't use it properly, you could easily see where something could be causing some damage, perhaps real serious damage.
Absolutely. And many of those important warnings will be on the product itself. You know, the ladder we talked about before has the warning right on it. Perhaps the table saw would. The equipment, and I've had cases where equipment's failed. That usually has warnings like exercise equipment. Don't lift the bar past a certain point, or don't use this equipment without another person. So you're always responsible for those warnings. I'm not so sure you're always responsible for the warnings in the manual because the manuals doesn't travel with the equipment, and the person who got hurt might not have been the buyer.
Good point. Good point. Thank you once again, David. We'll be with you next time, and we'll be discussing the wonders of real estate. Tough market, but some wonderful opportunities. So stay tuned. The Legal Matters discussion continues.